and we'll be taking attendance by all of the normal means this morning. So Dr. Matthews, are you ready to introduce our speaker?
Sure am. Sorry. Good morning, everyone. Kimberly Mutcherson is the co-dean and professor of law at Rutgers Law School in Camden. Dean Mutcherson is a reproductive justice scholar whose work focuses on assisted reproduction and abortion and maternal fetal decision-making, among other topics. Cambridge University Press published her edited volume of Feminist Judgment, Reproductive Justice, rewritten in 2020. Dean Mutcherson was a co-recipient of the 2022 M. Sharner Gilbert Human Rights Award from the Society of American Law Teachers and the 2021 Association of American Law School Inaugural Impact Award as one of the creators of the Law Dean Anti-Racism Clare House Project. Dean Mutcherson received her BA from the University of Pennsylvania and her JD from Columbia Law School. I have done a panel with her. She is intriguing, and I'm excited to hear her talk. She has many publications, and I'd like to welcome you, Dean Mutcherson, to OR Grand Rounds. Excited to hear your talk.
Thank you so much for having me. I'm gonna just start by saying I am not a WebEx person. So I think that you're seeing my screen, but I don't think that my video is on, if that's okay.
Yes, both are fine.
Okay, all right. So first of all, thank you so much for having me here. I've done grand rounds several times, but I got here early enough to sit in on the M&M, which I've never been able to do before. So thank you for allowing me to participate in that. So my plan today is to talk to you for about 40 minutes or so, and then talk with you for whatever amount of time we have left. I like to say that I am a lawyer who is not obsessed with the sound of my own voice. So I actually like to engage in conversation. So, first, my disclosure slide. Let's see if this is going to cooperate. Yes, nothing to disclose. I'm just me. So here's what I'm going to try to do with you all in the time that I have with you today. First, I want to talk to you about this concept of reproductive justice. As was described, I'm a reproductive justice scholar, and I think it's really important for folks to understand what that means and where I'm coming from when I talk about issues like abortion. Then I want to talk about how we got to where we are today in terms of Dobbs and the end of Roe versus Wade. And then I want to think sort of future looking about where do we go from here now that we're in this really precarious set of circumstances for patients and for providers. Just a quick note on language. I'll use women and pregnant women in this talk. I'll also use pregnant people and people capable of becoming pregnant, because obviously cis women are not the only people who get pregnant. But in my work and in reproductive justice in general, it's often really important, really crucial to remember that the category of woman matters both historically and in our present moment when we talk about reproductive oppression. So because of that, I'm not going to consistently use gender neutral language in talking about pregnancy. So let me lay out what reproductive justice is, and in particular, how it's distinct from talking about reproductive rights. So I want to situate us in the pillars of reproductive justice. So first of all, reproductive justice is a movement that was started by Black women in the mid-90s, and these were women who had been working in their communities for a very long time, doing community organizing and providing services, often in low-income Black communities, often in the South as well. And they were working with mainstream reproductive rights organizations, which were frequently run by white women, and often middle class or upper middle class white women. And so there was this really sort of significant rift between what these folks as activists were seeing on the ground and the kinds of issues that were being pursued by the mainstream reproductive rights organizations, in particular, the deep focus in those organizations on abortion and abortion access. So these founding mothers created a movement that was built from and focused on the issues that were especially relevant to their communities and to marginalized women in general, and a movement that would center the experiences of those particular women. So here's what reproductive justice is about. It encompasses a woman's human right to decide if and when she will have a baby and the conditions under which she will give birth. Sometimes you'll hear this referred to as birth justice, to decide if she won't have a baby and what her options are for preventing a pregnancy or ending a pregnancy. And then finally, and this is the piece that I find so critical, to parent the children she already has with the necessary social supports in safe environments and healthy communities, and without fear of violence from individuals or the government. And this was laid out by, let me just go back quickly, by Loretta Ross, who was one of the founding mothers of reproductive justice. And if you're a person like me who's obsessed with people who get MacArthur Genius Grants, she's one of the grant awardees from last year for all the work that she's done. So reproductive justice is human rights based, which makes it very distinct from the sort of constitutional rights paradigm that we tend to focus on in the United States. It is deeply intersectional. And when I use the word intersectional here, I'm really using it in the true sense of how that word was coined by Kim Crenshaw, who happens to be a law professor. And she was really sort of building on Black feminist thinkers who came before her and activists, and really thinking about how the experiences of Black women who sit at this intersection of Blackness and femaleness meant that our experiences of the world and our experiences of discrimination and oppression weren't simply about being Black, right? They were specifically about being a Black woman in spaces where that unique identity was meaningful. And so reproductive justice really picks up on that. It is rooted in the experiences of women of color, and it recognizes that reproductive oppression is experienced differently across communities of color and other marginalized communities. So RJ is expansive in ways that typical reproductive rights discourse is not, and frankly, never has been. That's probably obvious from what I've said already, but just to give you a really broad sense of all the different issues that are a part of reproductive justice. So when you have a majority Black city like Jackson, Mississippi, not too long ago, that doesn't have access to clean water, that is a reproductive justice issue. Criminal justice reform is a reproductive justice issue, right? Reproductive justice can't exist if Black and brown communities continue to be over-policed, over-criminalized, disproportionately subject to the death penalty and other extreme forms of punishment. Universal childcare, high quality public education, or the lack thereof in this country, inadequate access to health care, income inequality, voter suppression, overrepresentation of children of color in our child welfare system, homelessness, and housing insecurity. So I could go on and on and on, but I think you really get the picture by now. So what an RJ frame does is it really helps us to understand the deep connections between and among various forms of oppression and discrimination, and how those things feed each other, often in extremely pernicious ways. So I wanted to take time to really lay out the paradigm of reproductive justice, because if we want to build a world in which reproductive justice becomes our reality, we can't just focus on abortion rights, that we really have to think about larger systemic issues that impact choices about procreation and about parenting. So in other words, any conversation that I ever have about abortion is never just about abortion, right? It is about all of the things that surround the decision making that goes into having an abortion or not having an abortion. The other thing I think is really important that I want to lay out before I get to the law is really being also aware of the history, right, that is attendant to these conversations. In other words, the history of how this country has dealt with procreation, particularly for people from marginalized communities. So that means when I'm talking about abortion, I really place that issue within the larger context of reproduction and parenting in the United States, and specifically, frankly, on the many ways in which the law has failed so many people over the years by placing barriers in front of them, largely based on socioeconomic factors such as race, income, education level, disability status, histories of incarceration, immigration status, et cetera, et cetera. But I'm also really thinking about the spectrum of ways in which the treatment of Black and Brown folks across a range of issues impacts our ability to become parents and then to parent our children safely. And unfortunately, while we don't always teach this reality in our schools, this country's history is replete with examples of people with power using law and policy to control who gets to procreate and how, as well as who gets to parent and how. So think about things like the history of Native American boarding schools in this country, right? The idea that you would kill the Indian to save the man by basically taking children away from their parents and away from reservations. The history of eugenic sterilization laws in this country, and then this map in particular, I think is really important because we tend to have this sort of sense of, oh, when sterilization abuse was happening, it was this horrible thing that was happening in the South. When it was happening in the South, but it was also happening in the Northeast and in the West and in the Midwest. So it was really a large part of what was happening in the United States at the time. And then things like the Chinese Exclusion Act, which was an immigration law that basically was keeping Chinese women from immigrating to the United States when Chinese men had been brought here in order to work on the railroads. And the idea there was what we don't want is for people to come here and to have little Chinese babies who are actually American citizens, right? That was like horrifying for our government to think about. And so we actually passed laws to keep people from being able to come here. And of course, all of this is happening against this really important backdrop, which is the kinds of decisions and the difficult decisions that people often make about whether they want to have children and whether, and if so, how and when they want to do that, and then the decisions that people make about parenting. And the point that I want to make about choice, which is really critical here, is that choice in this context, right? When we think about the reproductive choices that people make, they're often, if not always, exercised within various kinds of constraints. So for instance, if you decide to have an abortion because your state doesn't provide an adequate social safety net, that's a choice, but not a particularly fair one for somebody to have to make. Or if you end up carrying a pregnancy to term because you're poor and the Hyde Amendment says that Medicaid isn't going to fund your abortion, that is also a choice, but not a particularly great choice. Or finally, if you're living in substandard housing because it's the only place that you could find that would accept your Section 8 voucher, that is also a choice, but again, not a very fair choice to have to make. So I'm always really suspicious of how we use the rhetoric of choice and the language of choice in this particular context, because so many people's choices are deeply constrained. So I said a lot there because, as I said, I really don't feel like I can have a conversation about the work that I do and the things that I'm concerned about without people having that kind of background information. And so to the extent that you've got questions or comments about that first part of the talk, please write them down because I'm happy to talk about them when we get to the Q&A. Now, I'm not going to try to give you a full history of the law of procreation and parenting in the United States. What I really want to do is zero in on some of the most crucial and relevant cases, including, of course, the abortion cases leading up to Dobbs, and talk about how both expansive and problematic Dobbs is. So there are basically three relevant constitutional rights involved here when we talk about reproductive justice. One is the constitutional right to procreate. The second is the constitutional right not to procreate. And then, of course, the third is the constitutional right to parent one's children. And so guessing that most of you have not actually had a con law class, let me just sort of explain what all of this means. So cases like Meyer versus Nebraska and Prince versus Massachusetts, very old cases from the early 20th century. And in those cases, the Supreme Court said that parents have a fundamental right to the care, custody, and control of their minor children. In Skinner versus Oklahoma, which was actually a case about a eugenic sterilization law in Oklahoma, which was basically a 3 strikes and you're sterilized law. So essentially, if you committed 3 felonies at the point where you were convicted of that 3rd felony, the state could apply to sterilize you because the thought process was criminality was passed through the genes. So Skinner versus Oklahoma decided that we had a right to procreate. And then Griswold versus Connecticut and Eisenstadt versus Baird, which are the cases that decided that first married people and then single people had a right to access birth control. And then, of course, finally, Roe versus Wade and Planned Parenthood versus Casey, which are the cases in which the court had first articulated and then supported a fundamental right to an abortion. So, one thing that I will say is that the Supreme Court has reinforced these rights over and over and over again, putting aside abortion, which we're about to talk about, even though none of them are explicitly contained in the Constitution. So let's now talk about abortion and talk about Roe and talk about Casey. So this is Norma McCorvey. She is the Roe in Roe versus Wade. At the time that Roe happened, she was a young woman who had grown up in Texas, the daughter of a single mom who was also an alcoholic. Norma got into a lot of trouble when she was younger. At one point, she was even sent to what was then called reform school. She got married and pregnant at 16, got divorced before that child was born, and subsequently relinquished that child to her mother. In 1967, she got pregnant again and gave up that child for adoption immediately after she gave birth. And then she became pregnant again in 1969. And at that point, she wanted to have an abortion, but she was in Texas. And Texas at that time said that abortion was illegal unless the pregnant woman's life was in danger. And in order to prove that her life was in danger, she needed to get confirmation from a panel of physicians if she wanted to get permission to have an abortion, which she wasn't going to be able to get. So ultimately, she ended up being referred to a couple of feminist lawyers, Linda Coffey and Sarah Weddington, who had been looking for a case to challenge the Texas abortion law. As a consequence of being a plaintiff in that case, McCorvey actually ended up having to remain pregnant, right? Because to not be pregnant then makes the case moot. So she gave birth to another child who also was put up for adoption. So in Roe versus Wade, it was a 7-2 decision made by a court that had no women sitting on it. And the court decided that abortion was a fundamental right. So the Constitution absolutely protected a right to terminate a pregnancy. They also said in Roe versus Wade that a fetus is not a constitutional person. So in other words, that a fetus is not on the same sort of constitutional footing as a pregnant woman, that the state has an interest in potential life, which is going to really become important for us as we move forward. And then they articulated this trimester framework, right? This framework for thinking about how do we regulate abortion. And the trimester framework said that in the first trimester, states could not regulate at all. It was none of your business, and a pregnant woman could make whatever decision she wanted to in the first trimester. In the second trimester, states could regulate, but they could only regulate to protect the health of the pregnant woman. And then in the third trimester, states could go as far as to ban abortion entirely, but any statute that banned abortion entirely in the third trimester had to have an exception for the life or health of the pregnant woman. That was the strongest articulation of abortion rights that we would ever see in the United States, and that was in 1973. In 1992, and the court decided Planned Parenthood versus Casey. That was the next really big abortion case. And this was the first time where people thought they really might overturn Roe, but they didn't do that. So the challenge parts of the Pennsylvania Abortion Control Act there were biased informed consent requirements. So not only do you have to provide informed consent, but the state is going to tell you what you have to say to an abortion patient, that you had to have a 24-hour waiting period, right, which was basically a way of forcing people to come to a clinic twice, that minors had to get informed consent from their parents. And if they didn't feel safe doing that, that there was a judicial bypass option. So instead of talking to their parents, they could talk to some random strange judge and tell that person that they wanted to have an abortion. And then a married woman who was seeking abortion first had to notify her husband of her intent to have an abortion. And then, of course, there were medical emergency carve outs and a whole bunch of reporting requirements. So in Casey, the court said, all right, we still believe in Roe versus Wade. So they upheld a constitutional right to an abortion, but they said the trimester framework was too rigid. We can't work with the trimester framework anymore. And largely, they didn't like the trimester framework because they said it didn't give enough weight to the state's interest in potential life. So Casey was all about providing more opportunity for the state to regulate abortion because the state had an interest in potential life. And in fact, the court said in Casey, the state's interest in potential life kicks in at the moment that a pregnancy begins, right? So basically, the moment of fertilization, the state has an interest in that potential life. So they rejected the trimester framework. They replaced it with the line of viability, and created a new standard for evaluating whether a statute was going to be constitutional or unconstitutional. So after Casey, the court said, well, spousal notification, that's not okay. You can't require an adult woman who's married to get permission to tell her husband if she's going to terminate a pregnancy, but you can have waiting periods, you can have bias-informed consent, and you can have parental notification as long as there's a judicial bypass. So if we take Roe and Casey together, this is basically what the law was before Dobbs, that there's a right to privacy in the Constitution, and it is broad enough to encompass a woman's right to terminate a pregnancy, that a fetus is not a constitutional person, that you cannot ban abortion before fetal viability, that if you do have a ban on abortion, it has to include an exception for life and health, that you cannot require spousal notification or consent, but you can require young women to notify or get consent from their parents as long as you provide judicial bypass. So not going to say much about June Medical Services. The reason why I put this up here, though, is that I want to be clear that in 2020, the U.S. Supreme Court got to see another abortion case, right? 2 years before Dobbs. And in that abortion case, they reinforced Casey and they reinforced Roe. And this was striking down an admitting privileges law in Louisiana. The only thing that changed between 2020 and 2022 is who sat on the court. Right? So nothing else had changed in the world, but what had changed was the number of votes on the Supreme Court where people were willing to overturn Roe. So the 2022 Supreme Court term was basically a path of destruction in a whole host of different ways, but particularly in the context of abortion. So I'm not going to walk through all the opinions in Dobbs because we really know what the upshot is. And the upshot was that Roe and Casey were overruled. The court said there is no constitutional right to abortion, and there is no constitutional right to abortion, one, because it's not enumerated in the Constitution. It is not explicitly laid out in the Constitution, and the word abortion doesn't appear in the Constitution. It's not deeply rooted in the nation's history and traditions. So shockingly, at a time when women couldn't vote and men were the only people making the rules, they did not make abortion legal. And that stare decisis, the idea that you rest on cases that have already been decided unless there's a really good reason to overturn them, that it didn't count in this instance for a whole host of reasons, including their assertion that there had been no reliance interest on the case, right? That women had not in any way shaped their lives around the idea that if they were to become pregnant in circumstances where they didn't want to remain pregnant, that they could have access to abortion. And then they tell us that the decision is limited to abortion because none of the other privacy rights in the Constitution involve potential life. So just one quick point to make, right? So the court says, well, we can't find that abortion is protected because the word abortion doesn't appear in the Constitution. So if you're wondering what other kinds of words don't appear in the Constitution, woman, abortion, sex, contraception, gender, parent, marriage, and privacy. None of those words appear in the Constitution, and yet the court has found a whole host of rights around all of those things. So let's talk about the fallout from Dobbs, which has been swift and it has been concerning. We are living with enormous chaos And the people who are paying the highest price for that chaos, as is pretty much always true, are obviously pregnant people and the most vulnerable of pregnant people, and not just pregnant people who are seeking abortions. One, the impacts of any kind of ban on abortion are not neutral, right? They are not race neutral. They are not income neutral. They are not age neutral. 75% of people who have abortions in this country are low income. So we know that that this targets poor women. Black women are overrepresented among the population of women who have abortions in this country. So that means that Black women are particularly impacted by abortion bans. About 59% of people who have abortions in this country already have children at home. So you're also impacting families here. And finally, about 60% of people who have abortions are in their 20s. So it's really young women who are also being impacted when we change the rules about abortion. So what we've seen, obviously, are clinic closures. Jackson Women's Health, the plaintiff in Dobbs, was actually the last abortion clinic in Mississippi, and so they closed as soon as the decision came down. The Guttmacher Institute did a review of what was happening on the ground 100 days after Dobbs. 66 abortion, and they looked at 16 states. 66 abortion clinics had already stopped providing abortions. Prior to Dobbs, 79 clinics had been open in those states. The only remaining clinics were in Georgia. In 14 of 15 states, there were no abortion providers remaining at all. And we also had some really difficult and complicated questions that arose for healthcare providers, particularly about how to manage miscarriages. So we've all seen these stories about women who are sent home, basically, or told that they have to wait until they are essentially at the brink of death before they can have an abortion, as long as the hospital can continue to detect any sort of fetal cardiac activity. And so those cases have been pretty heartbreaking, I think. We have seen people who are denied access to medications for medication abortion. So pharmacists choosing not to prescribe medications, which they are allowed to do, right? They can refuse to fill a prescription if their conscience tells them that they should not participate in whatever that medication is being used for. And then we've also seen shortages of medications, including medications that can be used for abortion, but that are also used for other sorts of illnesses. And the issues related to medication abortion are really just going to get worse, right? As states work to make it difficult, if not impossible, for people to get access to abortion pills, as states decide that telemedicine can't be used for medication abortion. And this is a really big deal, right? 90+% of abortions in this country have been first trimester abortions, and 50% of those abortions are medication abortions. So if you take away that option, you are taking away a big part of abortion care in the first trimester. In the many states where abortion is already banned and the many states where it will be banned in the months to come, we're also worried about what's going to happen to the next generation of abortion providers. Where are they going to come from? Where are they going to get their training from? And that's assuming that people will even be willing to go into abortion care. We're also significantly worried about the criminalization of pregnant people and pregnant women, in part because we know when pregnancy gets criminalized. And when I use that term, I'm thinking about things like women being accused of engaging in some sort of behavior that created a stillbirth, women who are accused of trying to self-manage abortions and therefore get sent into criminal court. That those kinds of that kind of targeting will increase in this new regime that we are living in. And of course, poor women and women of color are the people who are typically targeted when there is criminalization of pregnancy. So that's a pretty short list, although I would say a list that is big in terms of its impact. And that list of things that will go wrong will get longer in the months to come. I also, though, want to be maybe a little less negative, at least for a second, because there are some states that are going the opposite direction. So New Jersey being one of them, good for us in New Jersey, California, New York, these other states that are creating legislation specifically to become what people are calling abortion sanctuaries and to protect abortion providers and to protect abortion patients. So what we are looking for ahead of us is years of litigation, lots of legislation, and lots of conversations about what comes next and about what our priorities are in this new world that we are living in. So I am not a person, my steady state is definitely not optimism, right? My steady state is things are bad and things will always get worse, which is not necessarily the best way to live one's life, but what are you going to do? But I'm going to try to channel a little bit of optimism in this moment, because I think that there are opportunities here if people are willing to get on that bandwagon. So what are some of those opportunities? Well, one of those opportunities is to stop the criminalization of pregnancy, right? So one thing that we are definitely going to see is a shift in the focus of who is targeted for punishment. So for many, many, many years, it was a central tenet of the anti-abortion movement that you don't punish women, that women are sort of victims of the quote unquote abortion industry, that they're being coerced into having abortions, and so you should never punish women. Well, in a world of medication abortion where people can very safely self-manage abortions at home, that idea that you don't punish the person who is actually having the abortion is really going to have to go out the window. And so one thing that we can really think about is why should states be using criminal law in order to try to target women who are self-managing abortions or who are thought to be self-managing abortions, and those are two different things. This is also a moment where we could think seriously about attacking the maternal and infant mortality crisis in the United States. You all well know that the U.S. has the highest maternal mortality rate of any developed nation, that our maternal mortality rate actually went up from 2019 to 2020. It simply has got to be the case that we can do better here. And of course, there are significant race disparities both in maternal morbidity and mortality and in infant mortality. What's really upsetting here is that studies tell us that as many as half of all the deaths in this country that happen because of pregnancy complications could be prevented if women had access to better health care, if they received a higher quality of care, either during the prenatal period or while they're giving birth, and if they were also able to make positive changes in their own lives. The other thing, of course, that's very concerning here is that many of the states that rushed to ban abortion are also the states that have the highest maternity mortality rates in the United States. And what we're going to find is that there simply are not enough places to provide high quality care to women who are now going to end up staying pregnant where they would have had an abortion in the past. We already have a shortage of reproductive health care, particularly in rural communities and in some poor communities, and that's just going to get worse as we go forward. So these are issues that really should be coming to the forefront. We also have to worry about the future of sterilization in this country. We know that we've had years, decades of sterilization abuse in this country. So on one hand, what we have seen already is an uptick in women going to their providers and asking for permanent sterilization. Some being told no, some being told you have to get permission from your husband before I will do it, which of course is never required under law. But also the ways in which not having access to abortion becomes a lever that some healthcare providers can use to encourage people to get sterilization procedures who otherwise would not have been interested in those procedures. So we really want to worry about that kind of coercive practice being on the rise once again. We really need to worry also about how we are using language We've already seen anti-choice people trying to shift the definition of what an abortion is, particularly in the context of Plan B. Had a whole campaign around doing this, which then, of course, allows creep into the world of contraception. And so, luckily and happily, the FDA actually has stepped in here to clarify that Plan B is not an abortion, it's not an abortifacient. That is very helpful, but we're still seeing attacks on the FDA, not necessarily in the context of Plan B, but in the context of medication abortion. And then, of course, this is also a moment for us to really resist this narrative about personhood, this idea that a fetus is on par with, if not in some instances, more important and more worthy of protection than is the person who is pregnant. And of course, we also have to worry about, as we talk about personhood, what the implications are for fertility care. So, for instance, if a fetus or if an embryo is a person and someone doesn't want to use that embryo, you could imagine a state saying, well, that's no different than somebody dropping off an infant at a firehouse. If you've abandoned your embryos, then they should go over to the custody of the state, and the state should be able to give them to people who are willing to bring them to fruition, which would totally change the way that fertility providers interact with their patients. So I want to end with a story because I think that stories are just incredibly important. And in large part, in this context, I want to talk about the history here and the history in particular of gynecology, which we know is rooted in racism and in abuse of enslaved Black women. And so, in that context, I really think of Dobbs not as an aberration, but really as a validation of what reproductive justice activists have been saying, frankly, for decades. So, let me talk to you about the Relf sisters. The Relf sisters were two young women, Mary Alice and Minnie. They had an older sister named Katie, and they were a trio of young women who were living with their parents in public housing in Montgomery, Alabama in 1973. Mary Alice and Minnie, the two youngest who you see here, were both developmentally disabled. This family, like a lot of poor Black families in Montgomery at the time, was receiving a lot of different services from various organizations that were funded by the federal government, including the Family Planning Clinic of the Montgomery Community Action Committee. So people from the Community Action Committee were, in ways that are deeply problematic, deeply involved in demanding that the Relf sisters be given birth control without their consent, starting very early on. So in 1971, people from the CAC were giving experimental birth control injections to Katie, who was the oldest girl. Not too long after that, the two youngest girls also started receiving those injections. Then in 1973, an employee from the CAC brought Katie to the hospital and had an IUD inserted for her. She had not asked for it, and her parents had not consented to it. And then in June of that year, a nurse came to the Relf home, picked up Mrs. Relf and the two younger daughters, who at that point were 14 and 12, and took them to the local hospital. Mrs. Relf at the hospital was asked to sign a consent form, and she thought she was signing a consent form for her girls to continue to receive these injections, these birth control shots. She could not read, nor could she write, so she was relying on the healthcare providers to tell her what was going on, and she marked an X on the consent form. She was told to leave the girls at the hospital, which she did, and they stayed there overnight. The next morning, doctors administered general anesthesia to Minnie and to Mary Alice, and they surgically sterilized both of the girls. And I'll tell you, 14 and 12 at the time that this happened. No informed consent from the parents. The girls had no idea what was happening. And this picture is actually the two of them showing their scars from their sterilization procedures. And of course, this kind of abusive sterilization against two poor Black girls was part of a long pattern of sterilization abuse conducted in public hospitals in this country and across the country, in the South, in California, in the Northeast. So much so that, in fact, Fannie Lou Hamer had a term for these, right? She called them Mississippi appendectomies, because so many Black women would go into the hospital for various types of health care and would be sterilized, often without their knowledge, let alone their consent. Because a healthcare provider decided this is a person who doesn't need to have any more babies. Eventually, lawsuit is filed by the Southern Poverty Law Center. It ends up settling. The rules that we have today, in fact, about Medicaid and sterilization, their genesis is in these kinds of practices and in what happened to the Ralph sisters. So I wanted to share that story in some details because I think it's so important in the space that we're talking about today to really note the ways in which reproductive oppression and reproductive hierarchies have deep intersectional implications. For the Ralph sisters, it was the combination, right? It was being Black, it was being female, it was being poor, it was being developmentally disabled. All of those things coming together are what led to their unconsented sterilization at the ages of 12 and 14. And again, as I said, it really calls to mind the very pernicious history of gynecology in this country. And so with that, really, for this audience in particular, I want to end by really thinking about the fact that some of the worst forms of reproductive coercion and oppression in this country were supported by, if not in some cases initiated by, healthcare providers. So as the Supreme Court continues to whittle away at various rights, right? No abortion, no contraception, no right to procreate, no right to make decisions about how we raise our children, it is often healthcare providers who will be in the best position to identify problematic practices and to rectify them. So there are really serious questions that I really hope that people providing healthcare are asking themselves in this particular moment. What does it mean to provide ethical healthcare, and particularly ethical reproductive healthcare? What happens when what a healthcare provider thinks that they owe to a patient conflicts with what the law says they can do? How do healthcare providers avoid engaging in practices that drive patients away from needed healthcare? How do healthcare providers avoid using the authority of their position to coerce patients, either explicitly or implicitly, into decisions with which those patients are uncomfortable? Or put another way, how can healthcare providers support patient autonomy rather than undermine it? And in particular, how do healthcare providers, oops, sorry, that's me telling myself to stop. But just very quickly, let me finish. How can healthcare providers be cognizant of their own biases, whether those biases are explicit or implicit, and how they impact the way that they provide care to patients whose life stories and life experiences may be very different from their own? And then finally, how can you use your position as a healthcare provider to advocate for a better world and a better environment for receiving healthcare for your patients and for all patients? And I'm asking these questions. They are not questions to which there are easy answers, and they certainly are questions to which I have the answers, but they are questions that have to be answered in some way if we want to build a world in which reproductive justice is the norm, not just something that we think about in a fanciful way. So I hope that this is a time when people who are providing healthcare are really thinking about the role that they can play in doing things like helping us expand our social safety net, helping us to challenge a criminal justice system that is used to deal with public health problems, helping us to demand that there is comprehensive sex education and broad access to contraception, and hopefully helping us to reach a point where reproductive justice becomes the reality for all women in the United States. So I'm going to stop there, and I'm going to stop sharing.
Dean Mutcherson, thank you so much for this excellent talk.
Absolutely.
I see that Dr. Bayat has her hand up.
Hi, good morning. My name is Lily and I'm one of our family planning providers here. And I hope that you can hear me clearly because I'm driving.
I can hear you.
Oh, perfect. And I'm also really fangirling, so my voice might be a little bit shaky. I really, really, really appreciated your talk and your perspective, and I'm so happy you were able to share it with us here in this department. And I have, I think, two questions that I would love to hear your thoughts on.
Mhm.
The first, is I think most of us are aware that, the feminist movements in general, um, including those that led to the passage of Roe, have centered the perspective and lived reproductive experiences of white women. So I think now that Roe has fallen, we have to think about, as reproductive justice advocates, how we can reframe our, our fight for abortion rights to be more inclusive than it has been historically. And I think about that in particular in the context of New Jersey, where, we're hopefully going to remain, a mecca of abortion care and services. And I know that Dr. Matthews and myself here, who provide most of our abortion care, are very passionate about being able to use our position here to help women access the care and services they need, whether they're coming from near or far. So I would love to hear whether you have any thoughts on, as we, try to increase and expand our services here in New Jersey, how we can make sure to promote and center that reproductive lens, reproductive justice lens perspective, so that, um, we don't repeat our, our past mistakes. So that's my first loaded question. And then the second question is, what your thoughts are on how this Texas case with mifepristone could potentially impact mifepristone access here in New Jersey.
Absolutely. So first of all, I never have a conversation with people who are abortion providers without first thanking them for the work that they do. So thank you so much for the work that you do. In terms of your question, so I think that so much of what needs to happen in healthcare and medical care in terms of infusing reproductive justice fundamentals into that, frankly, starts in medical school. So that's one of the reasons why I love, I've taught in medical schools. I love to do grand rounds. I love to talk to people because I want people to be thinking about the work that they do and to be understanding the ways in which they can be part of the problem. Right. And I don't think that most people go into healthcare to be a problem. I think they go into healthcare to fix problems. And so it's really important that people are really cognizant of the ways in which they can be a part of the problem. So whether it is, not taking patients seriously and not even recognizing necessarily that you're doing that, pushing particular patients into, say, permanent sterilization instead of other forms of contraception. You hear cases sometimes of women who say, I went in and my physician said that they didn't want to remove my long acting reversible conception, that we should wait. So things like that are really problematic. So I think it's important, starting from medical school, to really infuse these issues into the curriculum, and then to continue to do so when people are out in the world and where people are out in practice. So the Texas case, so the mifepristone case. So first of all, we're living in a world where sort of like all things problematic come from Texas and Florida, right? And so the reason why this case is coming out of Texas is that the plaintiffs in the case, very specifically, right? They could have filed in so many parts of the country. They specifically went to Texas, and not just to Texas, but a specific district in Texas, so that they could get in front of this judge. And I say that just to lay out the sort of politics and the cynicism, right, of what's happening here. So a couple of things about the Miffy case. So first of all, Typically, in any sort of court case, the only people who are bound by orders of the court are people who are parties to the case. There's only one manufacturer of Miffy who is a party to this case. So if there is an injunction that is laid out, it focuses on that manufacturer, and other folks could still be manufacturing mifepristone. So that's the first thing. Second thing, which you all obviously know, is that the 2-drug regimen is the best regimen for medication abortion, but you can also do it with just misoprostol. And so there's miso is still going to be on the market no matter what happens with Miffy. The third thing that I'll say is that this lawsuit is just unprecedented in such a host of different ways. The idea that you would attack an approval that was made 20 plus years ago based on all sorts of safety data, not just from the United States, but that had already been approved overseas, and the safety profile that we've had over the last couple of decades here in the United States is just top tier, right? It is obviously safer to have a first trimester medication abortion than it is to have a pregnancy go to fruition and to give birth. So the questions that are being raised here about the authority of the FDA are questions that go beyond abortion. And I think if you were in front of a judge who was, and maybe this judge will surprise us, but if you were in front of a judge who is a rational person and who's simply applying the law, you would say that this lawsuit is just completely ridiculous. So my hope is that what we're going to see is that it's going to sort of dissipate. But even if there's a decision made that's a negative decision, it does not mean that, for instance, people in New Jersey are not going to be able to have access to medication abortion.
Thank you. I see that Dr. Sinofsky has her hand up.
Yes, I work with the American College of Obstetricians and Gynecologists, and I'm sure you know that they're very much putting a lot of effort into stopping all the limitations on abortions. One of the challenges that we have is that different states are making different laws. And ACOG would like there to be no restrictions whatsoever, but some of these states are putting up laws that have viability clauses in them or others, weak limitations and things like that. I mean, do you think that we do women in our country a better service by supporting things that would help give them at least some rights in their state? Or should we only back like an all or none philosophy, which may lead to them not having any rights at all?
Yeah, I mean, I don't think that we can back an all or none philosophy because there's too much suffering that happens in the interim when you do that, right? So, and even under Roe and Casey, there were always limitations on abortion access, from 1973 on. So the idea that you would just have, free reign within this realm is not reasonable to think about in the context of the United States. I think one thing that we can, though, demand is that to the extent that states are legislating how medicine gets practiced, and that's what they're doing, right? To the extent that they are doing that at least it can be, one, informed by something more than somebody's religious belief about abortion, and two, that the statutes that they are writing are clear. So much of what we are seeing now is people, healthcare providers who are saying, and I'm going to take some responsibility here because I know that hospital lawyers are a huge part of the problem. And so, my people are part of the problem here as well. But people not knowing how, exceptions for life are going to be enforced or exceptions for health are going to be enforced. So, that's the people who are, waiting until there's no fetal cardiac activity, even if it means that the mom is getting sicker in the process, or the folks who are saying, normally I would have, a year and a half ago, I would have offered you a D&C, but now I feel like I can't offer that to you, and I'm just going to have to send you home to finish this miscarriage. So at minimum, we need some sort of clarification so that people can actually practice medicine based on the standard of care. One of the cases that's happening in Texas right now, right? Because again, it all comes through Texas and Florida. One of the cases that's happening in Texas right now is 5 women who were denied abortion care in Texas, who were either miscarrying, or a couple of women who had twin pregnancies that were really problematic, and their doctors wanted them to do a selective reduction, right? So terminate one twin in order to make the pregnancy safer for the other twin, and for the pregnant woman. So that case has been filed in Texas, and the whole point of that case is to force basically Texas to say, this is what our medical exception means, so that doctors know how they can practice. So more of that is going to have to happen. And then my hope is also that there are some states where state legislators are starting to realize that their bans are too broad, that their language is too problematic, and so we get a little bit of a rolling back. But that is optimistic to think that that's what's going to happen, unfortunately.
I see that Dr. Matthews has her hand up.
Thank you for an amazing talk, and it's lovely to see you again.
Good to see you.
Yeah, a lot of the things that you've said about things that we should do, or amazing residents, or working within that framework of getting our medical students values clarification workshops and really talking to them about the history of OBGYN. So kudos to our amazing residents who were the ones that initiated having you here with us, which was lovely. But my question is surrounding the Reproductive Freedom Act of New Jersey and what that means for us if we have a change in the parties. Will that impact what will happen in New Jersey in the future if we were to have a change in or leadership, like a different kind of governor? Or is this something that's going to be embedded in New Jersey and therefore will not be impacted by whoever is in charge?
So there's nothing that you can do that will never be impacted by who's in charge, right? The things that are most difficult to untangle are constitutional amendments, and a statute is not a constitutional amendment. So anytime you get a switch in the state legislature, it's possible that they'll say, well, we don't like that statute anymore, or we're going to overturn it, or we're going to pass something different. I think that is very unlikely in New Jersey, but it's always a possibility. The other thing that I want to say about New Jersey, because people say very terrible things about New Jersey, and it's entirely unfair. But the other thing that I want to say about New Jersey is that New Jersey isn't just protecting people who happen to be citizens of New Jersey, and New Jersey women who are having abortions in New Jersey, that we're also protecting providers, right? We are protecting women who come here to terminate pregnancies. So statutes that say we're not going to release, we're not going to release information about people. We're not going to allow you to extradite people. And unfortunately, those things are frankly just as important at this point, because we do have these states that are trying to enforce their laws across their borders, which is creating its own set of really deep constitutional issues that we're going to have to sort out.
Thank you. Yeah, I'm actually on the committee for that. I have one last question if no one else has a question. So I guess my biggest fear as a abortion provider is that with all of this, that now we're attacking MIFI or Next Step, and Plan B was always under attack, even when Roe was standing tall.
Yep.
What might the future look like for attack on contraception? There's like contraception that are emergency contraceptions. Where do you see that in your law frame of mind, so I can prepare myself as a clinician on how to advocate so that this is not something that happens?
So 2 things on that. So one is that the anti-choice movement, right? Overturning Roe has been their plan for 50 years. So these are people who are patient. These are people who have money. These are people who plan, and who are really strategic. So, they're still working on getting all the abortion pieces in place, right? Because they want to attack medication abortion and all of that stuff. But contraception is on the list. Right? It has always been on the list. And so part of it is what I was talking about towards the end of the talk, which is trying to redefine abortion, which is why I'm so glad that the FDA changed the language on Plan B. to make clear that it is not actually it's not actually creating abortions. It is not an abortion pill, that it is contraception. But I think we're going to find ourselves doing more and more of that. So finding situations, for instance, where states are making it harder to access contraception, finding situations where states are sort of changing what the informed consent process looks like for people to have access to contraception. Huge issues I think we're going to see for young people, young women in particular, who are trying to access contraception. So, the future does not look bright. I think it's going to take a little while for us to get there, but I think that's definitely where we're going. And then the second thing that I'll say about that is sort of going back to the Supreme Court cases. So Justice Alito, in his majority opinion, said, this opinion is only about abortion. Abortion is this totally unique thing. It involves potential life, and so nothing else is on the chopping block. And then Justice Thomas, who, you will be hard pressed to find me say anything positive about Justice Thomas. But what I will say is, in his opinion, he said, look, the language that we have used in majority opinion, this language about how do you find rights in the Constitution and what rights should be protected, that language is broad enough for us now to be rethinking other cases that are unenumerated rights and that are rooted under privacy. So Griswold, Eisenstadt, right, our contraception cases, those become problematic. He raised the marriage equality cases, right? I mean, Justice Thomas is ready to just erase it all. He's really ready to go to the mat on this. Conveniently didn't talk about interracial marriage, shockingly. But so we're in this sort of very dangerous space right now, and we'll see what happens.
Dean Mutcherson, thank you so much for this excellent talk, and these questions are just as thought-provoking as your talk, so thank you very much.
Absolutely. It's great to be here.
All right, everyone. Thank you all very much. I hope everyone has a fulfilling and productive day.
Take care.